Welcome to You Can Win in Court. Sometimes it's not enough to be innocent. The legal system is complex, and occasionally the innocent are wrongly accused. Here we will discuss in layman's terms the nuances from real court cases to provide insights on how you can best prepare to get a fair chance in court. And now, please welcome your host, Dr. Petra Deeter.
All right, hi everyone. Welcome. Today we have a very important interview with Attorney Ashish Joshi. He has specialized in high conflict litigations and in high conflict litigation on many jurisdictions across the U.S. on the federal and the state level as well as internationally, and especially cases that involve parental alienation, child abduction, false allegation of child abuse, psychological maltreatment of children. So this is a very important interview for alienated parents because he's going to talk to us about what happened, like how do the custody cases go wrong when it involves parental alienation, and what your attorney should know about these sort of cases. Now, before I go into the interview, I wanted to make a disclaimer that this is not legal advice. This is for your information purposes only. Feel free to post questions, but all of these are just information from a general standpoint. And the other thing I wanted to say is that normally when we interview a lawyer, I try to make sure that I classify the jurisdiction, but we have a special privilege today because Ashish's experience is really not just strictly to a particular jurisdiction. So we're going to talk in a general sense. We're not going to stick to any particular jurisdiction. Now, before we go into the interview, I would like to acknowledge a number of people. These are people that have donated to help our effort here at Victim to Hero. And so those are Adolfo Jimenez, Anthony Jimenez, Neville Kadimi, Jenny Rivadeneira, Morgan Dundon, Michael Wild, Anita Macon, Phil Goldberg. So thank you so much for your support. Your support really can make a difference. Thank you. And also, if you wanted to donate, please go to our website. It's victimtohero.com. And our goal is to bring an awareness to this parental alienation. There's such a lack of awareness. So thank you. And my name is Petra Deeter. Now I'm going to turn my video off so that we can just focus on Ashish. Ashish, thank you so much for doing this. Really appreciate you. So now with a lot of your experience on these sort of cases, let's talk about, I think there's a misdirected attention on these cases because people tend to think that these are custody cases. It's about child custody, but really it's not, right? What is it really about?
Thank you, Petra. I would love to answer that, but if I could go into my background a little bit to put context into what I do. My practice primarily focuses on parental alienation cases and cases involving child abuse, also pathological enmeshment and international child abduction. So when doing a case of parental alienation, it is absolutely important in how you frame your case. As an attorney, when I'm before a court arguing alienation, I am careful to frame the case as a case of child protection. This is not about child custody. This is not about parenting time. This is not about getting more time here and there. It's essentially about protecting the child from ongoing psychological and emotional abuse. You mentioned the term high conflict, Petra, and I'd like to a little bit talk about that. Often judges and even lawyers representing the targeted parents are sometimes quick to use that term. And we should be careful in using that term, especially in a case involving parental alienation. Why? Because the moment you use the term high conflict, you are sending a signal to the court that each party is to be blamed here, that we have a mom and a dad who can't get along, and therefore cases of high conflict. In a case involving alienation, we have one parent who is alienating the child against the other parent. and we have the targeted parent who is desperately fighting to keep and save that relationship. So it's not a high conflict case. It is a case of child abuse, emotional abuse, and that's how you need to frame it for the court. And there are studies that have shown that psychological and emotional abuse is as harmful and as severe as sexual or physical abuse. No judge in his or her right mind will continue to keep a child in an environment where the child is subjected to physical or sexual abuse. The first thing they will do is to protect the child to make the abuse stop. Once the child is safe, then they talk about parenting time, supervised time, therapy, whatnot. In a case involving severe parental alienation, that should be the approach. We want to stop the abuse, and once the child is protected and out of the clutches of the alienator, we can talk about reunification, we can talk about intervention, we can talk about supervised parenting time, and a lot of other measures. Goal number one is to frame the case as child protection case, not about custody, not about parenting time.
Um,
Go on.
no, go ahead. So thing is, I mean, this is so critical, but how do we make sure that the court can view it that way? Because obviously, we have such an inconsistent acknowledgement of parental alienation out there. You know, sometimes in certain state or certain cases, it'll be viewed as something critical, and then sometimes it's not.
That's a great question, Petra. First of all, every jurisdiction in America has said something about parental alienation, and it's positive. Sometimes the courts do not refer to the term as parental alienation. Sometimes they may use terms such as pathogenic parenting or brainwashing of the child and whatnot. But every jurisdiction in America and world over has acknowledged the phenomenon and theory of parental alienation. So if someone tells you that so-and-so state doesn't really recognize parental alienation, that's false. Every state has done that in some or other fashion. Some states are far advanced than others in terms of providing intervention, but they do acknowledge the theory and the phenomenon of alienation. Now, how to frame the case? That's where you need a good lawyer. That's where your lawyer needs to understand the research. That's where the lawyer needs to look at the law and the case law in that jurisdiction and other jurisdictions. Or if you are representing yourself, you can do it as well. One of the important things to realize is to understand that the phenomenon of alienation is profoundly counterintuitive. Let me say that again. The phenomenon of parental alienation is counterintuitive, profoundly counterintuitive. And what do I mean by that? What I mean by that is that if you are a family practitioner and you do typical divorce cases involving typical child abuse, child custody issues, child parenting time issues, division of marital assets and whatnot, you can't approach parental alienation cases in that manner. If you have a case involving alienation and your client or your target parent comes to you and tells you about alienation and there is evidence to support the theory, you have to act appropriately. The typical pitfalls involved in dealing with a case of alienation is that lawyers think like lawyers. You are paying a lawyer to think like a lawyer. It makes sense, right? Except that in an alienation case, it doesn't. When you have a targeted parent who is anxious to go to a trial, who is anxious to go to a hearing, they may appear as tense, they may appear as intense, they may appear angry. And typically lawyers like to tell them, you gotta relax a bit. You gotta take it a notch down. You gotta show patience. You gotta show empathy. You gotta just cool your heels for a little bit here and let the time go by, because this judge or that judge is not gonna like it, how you come across and whatnot. Well, that's a mistake, because every day that goes by when a parent is losing out on parenting time when the kid continues to get alienated and alienation gets further and further entrenched, is a tremendous loss. The further the alienation progresses, we have psychological damage, sometimes behavioral and cognitive damage, and other issues as well. So it's pretty important to not use your professional intuition to deal with cases involving alienation. For example, if a child is remonstrating and refusing to go on parenting time and is 12 or 13 or 14 years old, typically lawyers like to tell the clients, well, just give him or her a weekend off. Don't enforce the time, don't rush and file motions for contempt. Just take it slow and the child's going to come around and you might have a better relationship. Well, if it's a case of alienation, that makes it worse, not better. Because the first thing you are doing is to send a signal to the alienated child, the child subjected to parental alienation behaviors, that he or she is in the driving seat, that the kid gets to control the parenting time. The kid gets to tell the targeted parent whether he or she is going to show up for parenting time or not. You are also rewarding bad behavior. If the alienating parent is orchestrating violation of parenting time, every time you take a step back and let that slide is a victory for the alienated parent. And all of a sudden, months go by and you suddenly have a new status quo. You have a new normal. And the judge finds out, well, the kid hasn't seen the parent for 6 months. There must be something wrong here. No one came to me, the judge, to talk about it. So let's go to therapy. Let's take baby steps to resume the parenting time, which you should have had all along. And let's go and talk about supervised parenting time, perhaps see what's wrong and whatnot. And you are already on a slippery slope at that point in time. So you can't use professional intuition, your clinical intuition, or what we call gut feeling, to deal with these cases. You have to do what the research demonstrates works, which is in an alienation case, the targeted parent needs more time, not less, with the child who is resisting the care contact and who is rejecting the parent. Before I go further, Petra, any questions on this one?
I think we have a lot of questions. So for example, particularly I saw a question about evidence. So the question said, we think we show lots of evidence, but it does not seem to be viewed as such. So what do you view as good evidence?
Well, there's a difference between allegations and evidence. Evidence is presented at a trial when you are an evidentiary hearing. And evidence could take form of many things. It could be under oath testimony of a targeted parent. It could consist of emails. It could consist of voicemails. It could consist of photographs, videos, other witness testimonies, expert testimony in terms of therapy notes or counseling notes. If there are CPS reports that have talked about statements from other witnesses, you could subpoena the CPS caseworkers or police officers. So there's a huge amount of different kinds of evidence out there. But there's a method. There's a way to prove a case of alienation in a court of law. And different lawyers like to use different methods. I typically like to use what I call the 5-factor model of parental alienation. And I do this litigation, these cases around the country. So it doesn't matter to me whether I'm in a court in California or in Michigan or New York or Florida. The method that is used to prove alienation in a court of law doesn't really change. And the reason I like the 5-factor model is that because it is well established in professional literature. Dr. Amy Baker out of New York has written lots of things about it. It's been studied well. Judges understand that. And you can streamline and organize your evidence to fit the 5-factor. So let's go with those 5 factors. Factor one, you have evidence of a child resisting contact with or rejecting a parent. Now, how do you show that? You can show that by violation of parenting time, that the kid refuses to go to parenting time, the kid refuses to get on the phone, the kid doesn't call back, the kid says things like, I never want to see you, I hate you, I don't want to be with you, I don't like to go and see my mom or dad. So lots of things there. You can put together this evidence for the court. Factor two is that there exists a prior healthy normative relationship between the child and the now rejected parent. So you can have photographs, you can have videos, you can have witnesses to testify about how at some point in time, not too much in distant future in the past, the kid had a good relationship with the now rejected parent. Look at the vacation pictures, look at the photographs, look at the birthday pictures, that in not too distant past, we had a good relationship. There's a baseline relationship here. This wasn't the case before. This is a new change in the situation. That's factor two. Factor three is an important one as well. There has to be absence of evidence of gross neglect or severely abusive behavior on the part of the now rejected parent. In other words, the parent who's being rejected by the child or with whom the contact is being resisted, there shouldn't be any findings of severely abusive behavior. For example, if the child has repeatedly seen the father engage in domestic violence, the child has been exposed to repeated fights, repeated physical assaults by one parent against the other, the child might align with the parent who is the victim of such violence. In that situation, there could be a legitimate reason for the child's rejection of the abusive parent. There could be cases of severe alcoholism. You might have a case where the child is resisting contact with a mother who has had several DUIs in the past, who has been documented and demonstrated to have severe problem with alcohol. You might have a child resisting contact with or rejecting a parent who was never around when the child was growing up. Abandonment, that could be an issue. So you need to look at the case thoroughly and make sure there is absence of evidence of severe abuse or gross neglect. Now, it's important that we are not looking for evidence of someone being perfect. This is not to say that the parent who's been rejected has to absolutely be perfect without any flaws whatsoever. No. So a parent, for example, who misses out on a few soccer games or who behaved inappropriately once or twice on some particular situations, that's not enough for a child to reject a parent. The key in parental alienation cases is to show to the court that the child's reaction is so disproportionate to what that parent has done or could have possibly done in the situation. Because in most cases, the reasons given for the rejection are absolutely frivolous. So that was factor three. Let's go to factor four. Factor four is presence or evidence of alienating behaviors. There are 17 typical alienating behaviors that have been well, and again, Dr. Baker, Dr. Richard Sauber, and other professionals have written about it. And, right. So it's not necessary to have all 17 in a case. You could have, let's say, 4 or 5 of the 17 factors, but still it could be a case of moderate to severe alienation. But you do need evidence of some of the alienating behaviors. Now, sometimes people ask me, well, how do you find that evidence? I mean, do I have to hire a private eye to just go around and videotape other person? No, but you can try to extrapolate evidence from other sources. For example, you might have a police report where the alienating parent was talking to the police officer and the kid was present at the same time in that area where the interview was conducted, and the alienating parent badmouths the targeted parent. You might have a school teacher who might be willing to testify that the father or mother, whoever is the alienating parent, was bad mouthing the other parent in front of the child. You might have emails from the alienating parent where the child was copied on. So that's campaign of disparagement, bad mouthing. There could be other evidence as well in therapy notes, eyewitnesses. The kid might have made statements to other people saying that, well, when I go to mom's home, after I visit my father, mom continues to grill me and ask all sorts of questions about what I did with the father, and she's not happy if I tell her that I had a good time. And again, I'm just using gender as an example. It's not, alienation is not a gender game. Alienation is being engaged by fathers, and alienation is being done by mothers as well. So it's not a particular monopoly or by any gender by any means. So evidence of alienating behaviors, that's factor 4. And the final factor is signs of alienation present in the child. So there are 8 typical symptoms of alienation that are present in the alienated child. And the child needs to demonstrate some of those signs. Again, you don't need all 8. You could have 4 or 5 or 3 or whatever. It still could be a case of alienation. Some of the signs are borrowed scenarios. For example, when the child talks about things that the other alienating parent has been complaining about, and uses the same words, parrots the same language. Another sign is what professionals sometimes call splitting, which is the child has a black and white view of the parents. The alienating parent, the favorite parent, is absolutely in the white. That parent can do no wrong. He or she is worshipped, put on a pedestal. The targeted parent can do no right. He or she has never done anything right. The child sees absolutely no value, no good thing in that parent who's rejected. So it's polarized view of the two parents. That's a sign of alienation as well. There's other thing is called the lack of ambivalence, that the child doesn't show any ambivalence whatsoever. Rejecting a parent, there are no feelings of ambivalence. The child is often cruel, defiant, rude, and there are no feelings of guilt about rejecting the parent. It is also important to note that in many cases of alienation, children who are absolutely horrible to their rejected parents are defiant, rude, disrespectful, are absolutely angels in other parts of their lives. I mean, this kid who is absolutely horrible to his mom and rejecting the mom, who is a targeted parent, calls her horrible names, is great in school, gets straight A's, is a soccer star, or plays a wonderful piano, is polite, respectful. So professionals who don't understand alienation often take a pause and say, well, let's wait a minute. Let's not rush into reunification. If there must be something wrong with the mom, because the kid's doing great in school, why upset the apple cart? Let's take baby steps and whatnot. And they need to understand how the child is compartmentalizing things, and there's cognitive dissonance here. And that's a sign of alienation, and you need help faster. You need more reunification. You need more time with the parent who's being rejected, not less, to counter those alienating behaviors. So that's how you prove alienation in a court of law. Now, having said that, I'm sorry, go on, Petra. It's better if you put your video on so I can see you, and if you are going to ask a question, we can have a conversation that way.
I can. I was hoping to just film you, but I can. I think you just mentioned about it, sometimes the other parent will wave around this thing saying, hey, the child is thriving, right? And exactly like you said, it's actually an escape mechanism for the child. That's the only place that the child can actually focus on to try to be safe. And this has been proven and published, in peer-reviewed publication about this. So for people that are interested, we also did an interview of Dr. William Burnett who also talk about these 5-factor models. So we have a video on our Facebook, so you can also check that out. So these five factors are so critical. So one of them is about proving that there's no existence of serious allegation or abuse, right? But these cases are riddled with false allegations. So before you get to the custody, and I have interviewed hundreds of parents now where there were multiple child protective services calls that have filed, unsubstantiated, and then there's false allegation where police are called, and and even in the custody cases there's all these allegations. So because essentially they try to undermine this particular factor and try to say that, oh, the targeted parent is abusive or negligent in some way. So how do we overcome these false allegations?
That's a great question, and you just had the answer right there. The factor three requires absence of evidence of gross neglect or severe abusive behavior. It doesn't say absence of allegations. There could be 1,000 allegations made against a rejected parent, calling him or her abusive, neglectful, whatnot. But what's the evidence? Show me the evidence. We could have CPS complaints, we could have police reports, but has that parent found guilty of a crime, of an abusive behavior? First of all, has it been documented? Was that parent prosecuted for that kind of abusive behavior? Did he or she plead guilty? Is there a CPS, Child Protective Services substantiation of that behavior? If that's the case, we need to look at it closely. The other issue is that you might have that. You might have a case where, let's say, there was an altercation in the home and mom and dad were fighting or arguing about each other. Someone pushed someone, police were called, and someone was taken out of the house, arrested, but the charges were or were not brought. Ultimately, it was dismissed down the road, or someone had to take anger management class and whatnot. Even if that's a finding made of some sort of inappropriate behavior, abusive behavior, the question then to ask is, was that situational? Did it just happen one time or two times? Or was it systemic? Was that behavior prevalent in the marriage all throughout? Was the child exposed to that kind of behavior all throughout? If you have evidence to show that the child had a really good, healthy, wonderful relationship with the parent who is being alleged to be abusive, but somehow after this one incident, all of a sudden the child now is petrified, is terrified to be with the parent, and is rejecting the parent completely. Well, that's not proportionate reaction. That's disproportionate reaction. So we need to look at it closely. In some instances, you could have a hybrid case that there might be some legitimate justification for the child to reject that parent. And if that's the case, you need to work on that dynamic as well. So there's a difference between having evidence of abuse or then just allegations of abuse. But what I would like to also talk about is that targeted parents and the lawyers should think very carefully before using the term parental alienation. Because as with many things in life, there are good things and bad things about the term parental alienation. The good thing is that in the past decade or so, we have had court decisions from one jurisdiction after another where the courts have acknowledged the existence of parental alienation and have found it to be severely harmful to the child. Have called it emotional abuse, called it psychological abuse, have called it brainwashing, programming, they have changed custody. Right. So the good news is that the courts have come up with great decisions acknowledging parental alienation, and they have intervened to provide the necessary measures. The negative side of that, or rather the bad side, is that because the term is now widely accepted and understood in the courts, people have started using it in a much looser fashion. You know, you sometimes see parents rushing into the court or lawyers rushing into the court and filing motions claiming alienation, parental alienation. The moment someone behaves in some suboptimal manner or not in a completely best way, I mean, there's a difference between bad parenting or poor parenting or suboptimal parenting and parental alienation. And you need to be careful about it. because the last thing you want to do is to desensitize your judge by overusing or misusing the term parental alienation. You don't want to be the parent or the lawyer who cried wolf. And the last thing you want is to lose credibility in the court. So think carefully before using the term alienation. You might have some other issues. You might have a situation where one parent is undermining the other parent. One parent is, acting inappropriately, making some bad decisions. And by all means, though I'm not saying to tolerate those things and not complain about it, but before you use the term parental alienation, make sure that's what you have in your case.
So
So,
then, with
yeah, go on.
so with that, I mean, one of the reasons I think the term is becoming a little bit more controversial than it should is that there's false allegation where actually the alienator is turning around and claim alienation by the targeted parents. And that's one of the questions in the chat room right now is that someone said, my ex actually uses five-factor model to frame me even though I'm being alienated. So how do we counter that? Because, obviously now the judge it's all a big mess.
That's not unusual, unfortunately. Gaslighting happens in many cases, but at the end of the day, the proof is in the pudding. Is the child rejecting the targeted parent, or is the child rejecting the alienating parent? If the targeted parent is being falsely accused by the alienating parent, well, who's the child rejecting, first of all? Is a five-factor model applicable? Because remember, the first factor in the five-factor is that child must be resisting contact or rejecting the targeted parent. That's one. But again, present the evidence. The problem arises when many lawyers file motions after motions of petitions with the court, and they engage in what I call a paper war. They are waving paper all around, and pretty soon the judge has a file this large in front of the judge, but there's never been an evidentiary hearing. There's never been a trial. There has never been evidence put on the record as to what the case is about. Lawyers go to the court, they make oral arguments, they make deals in the hallway, they come out, and you have a band-aid put on a gushing wound that doesn't take care of anything. So you need to present evidence, you need to ask for an evidentiary hearing. The other related issue is that be very careful when you ask for an attorney for the minor child. If you are being asked to agree to an appointment of a guardian ad litem or a lawyer guardian ad litem or a minor's counsel or child's attorney, different jurisdictions have different names for this, you have to be very careful about it. First of all, do your due diligence. Find out what this professional knows about parental alienation. Has he or she handled cases of alienation? Are there court opinions that have referenced their work in this area? Have they published anything? If so, where are the articles? Read those. Have they presented on parental alienation? Look up the seminars if you could. Ask your lawyer to interview these people and ask questions about it. Because what can make a case of alienation far worse is to get an incompetent professional on the case who doesn't know what he or she is doing. A guardian ad litem who has no idea about parental alienation could mean well. They want the child to have a relationship with the targeted parent, but they absolutely don't know what's going on. They rely on their professional intuition. They try to see this case as any other case. They start giving recommendations, but what they end up doing, perhaps unintentionally, is to over empower a child who is already over empowered to begin with. An alienated child is a weapon that is used by the alienating parent against a targeted parent. That child, if it's a case of severe or moderate to severe alienation, is absolutely defiant, refuses to see their targeted parent, makes up all sorts of stories, is suffering from cognitive dissonance, has trouble in recapturing reality, is using borrowed scenarios from the alienating parent. And a professional who is not trained in these cases just takes a look at that dynamic. And the first reaction is, whoa, let's take a step back. Let's have a cooling off period. Let's not enforce parenting time. Let the kids settle down. And by and weeks go by, months go by, the targeted parent is not seeing the kid, the situation gets far worse. And then you go back to court and people are trying to wonder what's going on, what's happening here. So it is absolutely important that if you are going to have a professional appointed by the court, you need to make sure that he or she is knowledgeable, experienced, and skilled in the area of parental alienation. Otherwise, you might end up in a worse situation than you were already to begin with. Because then the professional comes in is seen as a neutral. And all of a sudden, if this neutral professional doesn't know the dynamic, doesn't know what's going on, the alienating parent now has two lawyers fighting for him or her, his or her own, and the guardian ad litem or the child's attorney who's going to come and tell the judge, well, my client doesn't want to see the mom or dad because of so many reasons. I don't know what's going on, but it's not important or it's not prudent to force or enforce parenting time for whatever reason. And that's a mistake. In fact, people who are interested in reading more about this could go to my website. And within the publications, you will find articles about guardians ad litem and the role in cases of parental alienation. It's a two-part article that I wrote about, which has cites to the professional literature and cases from other courts around the country which have explored this problem. So that's a big problem in the family court. And unfortunately, what happens is that judges rely on the local professionals. Often the county has a list of professionals who function as guardians ad litem or minors counsel, and they just look at the list and the next name on the list gets appointed. Very rarely does any judge or a magistrate or even the lawyer asking for these appointments puts work into deciding or checking whether that professional is experienced or not. So that's a big issue.
That is a very big issue because, like you mentioned earlier on, that this issue is very counterintuitive. When you see a child rejecting a parent, the general intuition is saying that, oh, there's something must be wrong with that parent. That parent must have done something serious, but it's completely opposite. So a lot of professionals are not trained in this. So what happened, because with guardian ad litem, parents don't usually get to choose. So if you happen to be assigned with a guardian ad litem that is not, familiar with this, what is the remedy? Like, what kind of action can you take so that you can demand a professional that is really experienced in parental alienation?
Well, I can speak about other professionals, what they do or what they don't, but I'll tell you what I do, what I like to do. If there comes a time when the judge is talking about appointing a guardian ad litem, I definitely let the court know that our case involves allegations of parental alienation. And before we appoint a person, we need to ensure that he or she is knowledgeable in this area. I would have no hesitation in picking up the phone, calling the person, checking them out in terms of their website, their publications, their background, asking other professional colleagues about them. If I come onto a case where a guardian has already been appointed, before I got into the case and it's clear that he or she doesn't know what they are doing, I would not hesitate to file a motion to discharge them. Now, it's not seen as playing nice in the sandbox, and sometimes it's sometimes seen as over aggressive. It's sometimes judges frown on it, but better to make a record up front and point out to the court as to what that professional is missing out on, what that professional doesn't seem to see what's going on, the errors and omissions, rather than wait out and complain once a professional has submitted a report or has expressed an opinion. Because then you are just seen as complaining about sour grapes, oh, you don't like the results, so you are pointing fingers at everyone. It's better to point out from the outset as to what's going on. Educate them, send them the research, send them the cases, but you have to work with your lawyer in doing this in a respectful, in a professional way, not to start lashing out, sending inappropriate emails, or be getting personal with them. Which brings me to one other related issue. Targeted parents are hurting and they are in a very painful situation. It's no different than undergoing trauma. When your flesh and blood is rejecting you as a parent, it is very painful. And often they lash out. They sometimes put things on social media. They start putting things on Facebook, for example, or other social media platforms. They start talking about the judges. They start copying and pasting the court filings. They start posting pictures of the children. They start lambasting the lawyers involved. And it's not helpful. You don't want to be in a situation where you are on the stand in a trial and the opposing counsel brings out this evidence in front of you and starts cross-examining you and talk about judgment calls and important decisions. You don't want to be in a situation where you're posting the Facebook ridiculing a judge or a lawyer or someone else is shown to you and presented as evidence of inappropriate behavior. It would be easy to just characterize you as someone who lacks judgment, someone who has problems with impulse control. And if this is how you behave on the social media platform, the argument would be made, Your Honor, imagine what goes behind the closed doors with the child. No wonder the child doesn't like the mom or dad. So be very careful about it. There are plenty of groups out there which are support groups, which are great in terms of providing education, help, guidance, but then there are also groups which are nothing better than gossip groups, which all they do is vent about professional. They post negative comments about other professionals, and you have to be judicious about where you are posting, what you are posting, and of whom about whom are you posting. Some judges are extremely sensitive about a parent who is posting pictures of the kids on social media. They won't tolerate that. They won't like it. So be careful about what you are doing. Protect the privacy of your children as well. It's one thing to file a motion bringing out all your grievances in front of a judge. It's another thing to just go out on the social media and lash out without any sort of filter there. So that's something to think about. I typically recommend to a parent to get a professional coach. If the parent has resources to retain a therapist or a counselor or a coach, it is highly recommended. One, they will help you go through this tough situation. They will prepare you emotionally, they will prepare you mentally to go through this litigation, which is a tough task. And they will do it in a way that they're trained to do this. And it's better that you get someone like that rather than treating your lawyer as your therapist. Lawyers get burned out. Often lawyers will just check out and stop responding to emails or text messages or calls because it's the same old client or he or she is intense. It's difficult to get off the phone and it's painful. I get it. When you are the targeted parent and you are the rejected parent, you want to talk. You want to scream on the top of your voice about why isn't anyone seeing my pain here? But the professionals on the other end, the lawyers are dealing with several other cases. The judges have thousands of other cases. So if you are acting out and if you are behaving in a way that's considered or that's seen as bad behavior, you are only shooting yourself in the foot. When you are in
Yeah,
a hole, stop digging, you
I
know.
think it's so important, actually. It's so important in these sort of cases. Unfortunately, the targeted parents are victims. So, like more than 90% of cases that I interviewed, the targeted parents are suffering symptoms of PTSD because they have experienced
Yeah,
trauma. Because
yeah.
it is direct attack at them as a person, as a human being. It's not like, somebody scratched your car, it's just an object, but this is personal. It's about you as who you are and about you as a parent. And then it also attacks that very important, the most important bond that you have, which is your children. So it's it's unfortunate because the victim here is it tends to act, like you said, agitated and afraid, full of anxiety. And so, but then at the same time, um, you are being in front of the judge where you are being judged as a character, whether you are a reliable witness or not. So it's very important. I think this is a very important advice for parents, is to figure out a way of finding support somewhere else, so that when it comes to the legal battleground, you are coming with clear-headed and full of reasoning and evidence. Um, so you mentioned about, you need
Just
to.
say something over there. What you mentioned is very important, Petra. And some experts have written about this, and they've talked about how the targeted parent demonstrate four A's.
Steve Miller.
Agitated, yes, agitated, anxious, angry, and afraid. And the alienating parent typically demonstrate four C's, as you know: charming, cool, composed, and convincing. And it's very difficult to go through that, especially when you are being attacked, when you have been gaslighted, when you have been falsely accused, and you are incensed about how the school teachers, for example, now treat you in a different way because of all the false allegations. And you see that all that, but lashing out on social media and complaining about it, especially if you're going to use the names and people involved in your case, seldom does you any good. And that's where a good coach comes in handy. Even if you cannot afford to find or retain a coach or a counselor for this, look at the articles. There are other articles written by good professionals which talk about going through experiences with a targeted parent. Amy Baker has published good books on it. Dr. Warshak has written about it. Uh, they look at those chapters, and there are plenty of good tips. It's a long battle. You have to prepare yourself for a long haul. It's not going to be over quickly, and you need to present the best front possible in the court of law.
Um,
Um,
yeah.
Go on.
So you mentioned about, okay, make sure that you get the right professionals involved. So if you find that a professional is not experienced, you wanted to intervene as early as possible. But let's say if you got you're coming late, you didn't realize this problem, and now you became aware, and you notice that either the counselor or like the guardian ad litem, or maybe the therapist or the social worker crossed the boundary. How do we what should we do here? How do we, are we suing them? Are we like, how do we hold them accountable?
So holding the professionals accountable is absolutely important. Now, whether that professional happens to be a judge, a lawyer, a social worker, a therapist, or any court involved, a court appointed professional, but you have to do it in a respectful manner. You have to do it in a professional manner. It doesn't help you by sending a nasty, insulting letter to a therapist or a judge, God forbid. I mean, that would be absolutely disastrous to your case. That would, in fact, you would play in the other side's hands. But let's take a hypothetical. Let's say the child's therapist is sending inappropriate letters to the court. Let's say the kid's therapist is saying that, oh, the kid's traumatized and the kid shouldn't be going to see the mom, without doing any fact checking, without doing any critical thinking, without even talking to the rejected parent, talking to any collateral sources, just sends out a letter to the judge. Now, that in most situations is highly inappropriate. And I would argue that it would run afoul of the ethical guidelines and the professional rules of conduct. In that situation, you should have your lawyer prepare a letter about the violation of the guidelines. If the professionals say it's a psychologist, use the guidelines by American Psychological Association. There are specific guidelines and codes of conduct, ethical principles of code of conduct. Point out the violation of the guidelines. Point out how that professional did not bother to check with the targeted parent. Point out how there's a crossing of boundaries from a therapeutic role to a forensic role. If the letter was sent to a judge, file a motion. Ask that the therapist be taken off the case, that the letter that was sent to court is ex parte communication, should be stricken from the record. Make a proper record about it. I mean, if your lawyer is not doing it, then that's a serious issue. There could be a strategic reason, I don't know, but it's highly inappropriate for this kind of conduct to continue. The same with a judge. If you have been asking for an evidentiary hearing or a trial and you are simply not getting it, file a motion. If there's a possibility of taking the matter to the chief judge of the county or an appellate division, do it. We see time and again where the Court of Appeals reverse some situations or some cases and send it back to the trial court for suspending a parent's time without holding an evidentiary hearing. They routinely tell the trial courts that you can't take someone's time away. These are constitutionally protected rights, parenting rights. They are protected under state and federal constitution. And before you take someone's parenting time away or suspend parenting time, a judge has to hold an evidentiary hearing or has to make some findings of fact. Different jurisdictions have different rules about it, but somewhat uniform rule is that there has to be a finding made that it would be not in the best interest of the child to continue with the parenting time, or somehow there is a danger to the child. But you can't do it on an ex parte basis without any evidence on the record. So ask questions to your lawyers. Why aren't we doing this? And if you're not getting satisfactory answers, maybe it's time to look elsewhere. Think about it. At the end of the day, it's your life. These are your kids. And you need to do your diligence. You need to dig deeper in that. But you need to do it in a way that is professional, that is respectful. What sometimes makes a matter worse is, let's say a therapist sends a letter which was inappropriate to begin with. The targeted parent lashes out in an email to the therapist, starts calling their office, screaming on the phone. The staff gets concerned about it. And next thing you know, you might have a PPO against you. You might get a personal protective order against you. You might get a restraining order against you. So all you did there was to prove to the judge that, well, there are some concerns. There is some concern about your behavior, your mental health, your impulse control, and the therapist was perhaps right in complaining about it. So be careful not to play into the hands of the alienating parent.
So it really comes down to having a really good team around you, having a good professional attorney who truly understands this. Um, so at
You
what
need
how
this is a specialty field. For example, you don't go to, if you have a case of medical complications, let's say, for example, you are accused of something horrible, uh, shaken baby syndrome, death of an infant child. You're going to go to a lawyer who understands the science of the shaken baby syndrome. You're going to go to someone who understands how the brain works, how the lack of oxygen flow to the brain could result into death or injury, who understands the science behind it. You're not going to go to a personal injury lawyer or a regular divorce lawyer and get them to defend you against that case. Same with the cases of pathological enmeshment and parental alienation. These cases require specialized knowledge, they require experience. You need to make sure that your lawyer is up to it, or if not, that your lawyer is, he or she is encouraged to get help. There's plenty of research out there, professionals who can help out. I mean, I frequently get calls from other lawyers about, I have this expert on the stand, I need to depose them, I need to cross-examine them. What should I do? What can I do? I'd be happy to share my knowledge. Sometimes I'm brought on the team for a particular objective or a particular area, such as deposing or putting an expert on the stand. There are various combinations to do this, but the resources are out there, Petra. And the good thing about these times is that we have so much research coming out in terms of peer-reviewed articles, in terms of books, in terms of judicial opinions from courts around the country, that it's a matter of putting it all together and putting a team together.
so it's unfortunate because it then becomes a case of who has the most money, because unfortunately all of this takes a lot of money and then also time, because these cases can drag out sometimes for a decade. So for parents that can't afford it, it's really about education, self-education, isn't it? And how do we get the judge to agree to acknowledge the five-factor model, for example?
Judges do. To my knowledge, no judge has said that the five-factor model is faulty or that I won't recognize it. So sometimes, and that's actually a great point. On some occasions, let's say when I'm coming into a case outside of Michigan, where I live, sometimes a local lawyer will tell me, well, I know that the client really wishes to present a case of alienation, but let me tell you, Mr. Joshi, our judge is not a big believer in alienation. Our judge doesn't really like that term. He or she is not going to go for it. And first of all, I don't know if that's true or not. I don't know whether judges say these things or not. But if they are true, then that's absolute nonsense. It's like a judge telling a lawyer, well, don't you bother arguing about domestic violence or presenting evidence of autism in my court because I don't believe in that. That's ridiculous. I mean, that judge, if that's true, doesn't belong in the family law bench. And I would have no problem in filing a motion to recuse that judge if those comments are made on the record, because that shows you bias. How can you expect someone to judge a case who says outright, I don't believe in alienation? There's science proving that. There are peer-reviewed articles that show that cases, there are judicial opinions. It's like someone saying, I deny science and I don't believe in science. So often what happens is that it's a case of lawyers being lazy at times. They don't want to make those tough arguments. They don't want to do the research. They don't want to learn the law. They don't want to be in that position where they are seen falsely, in my opinion, as aggressive, quote unquote aggressive, And you have to push the envelope. You have to be an advocate for the client. You have to make these tough arguments. You have to tell the judge to take the kid away from the alienating parent, the no contact order, financial sanctions, jail time. I've asked and won jail time for alienating parents. Unless you, the lawyer, are putting a case of child abuse in front of the court, and that alienation is child abuse, the judge is not going to be bothered. If you appear to just take it in your stride and let the parenting time violations go unpunished and not hold people accountable, no one's going to do it on your behalf. I mean, these people are hurting. We are talking about devastating consequences to the children from alienation. We are talking about age studies. I'm sure you know the adverse childhood experiences studies.
Yes.
We have evidence and research that tells us the severe long-term consequences to children who go through alienation. And it would be absolutely unconscionable for any lawyer who is representing the targeted parent or representing the child who is undergoing alienation to not go to court in the fastest way possible and to present the case in the strongest terms possible.
So what about if you have gone through all this and you've proven parental alienation? Sometimes judges still seem to hesitate because intervention is about really removing the child from the alienating parents for a limited, at least like 90 days or something like that.
Depends on the case. Depends on the case. If
Right.
it's a case of moderate to severe, then yes.
Right. So, but then some judges are hesitating to really put the right kind of judgment on this. So sometimes it's because the child is a teenager. So there's this argument about the child preference. And then the other argument is that the child now reacting and say, I'm going to kill myself, I'm going to hurt myself. So the judge is scared. So how do we handle those cases?
I like to bring that evidence up in my case in chief, which means that when I'm presenting a case of alienation and when I'm having an expert testify about interventions, I ask that question because every judge in the back of his or her mind is going to think that we have a 15 or 16-year-old who wants nothing to do with this parent. And these people are asking me to take the kid away from the favorite parent and put them with the targeted parent. And am I going to have a disaster on my hands? Am I going to be in the front page of the local newspaper if the kid runs away? Am I going to be accountable if the kid does something crazy, harms himself or other people, So Dr. Richard Warshak wrote a great paper on this. And I think it's called Top 10 Fallacies that compromise decisions in courts and in therapy on alienation.
Yes.
And one of the fallacy, the myth, is that the courts are powerless when it comes to adolescents, older teenagers, 15, 16-year-old. And that's a myth. The research demonstrates that when the court lays down the order and tells the kid that this is the court order and you are expected to follow the court order, alienation goes down. The burden of the loyalty bind is lifted from the shoulders of the child. We don't have research studies that have shown the kids running away or jumping out of windows and killing themselves or hurting themselves when they're put in the specialized program and when they are in the no contact order. The research shows the opposite, that programs like Turning Points for Families or Family Bridges have success outcome studies published which show a remarkable degree of success. But if they are coupled with no contact order, because the kid needs to reunify with the targeted parent and also develop resiliency against future potential alienating attacks as well. So you present it to the court, it's part of the prescription. If you have a medical diagnosis and there are doctors saying that the only way to defeat this disease, there is a cure for it, and this is the dosage of the medicine that you are required to take, or it requires your surgery, no judge is going to micromanage that. You don't see judges saying, no, I agree with chemotherapy, but I won't agree with that, and I do this and do that. That's not their role. Their role is to listen to look at the evidence, look at the expert testimony, weigh the expert testimony, and if it fits the bill, make the ruling. If the kid runs away, we have the police. They'll bring the kid back. Why do we allow the kids to run the show in this situation where in any other family court, in any other situation, we don't do that? We don't ask the 15-year-old if they are continuing to go to school, if they'll continue to go to dentist, if they'll continue to go for medical appointments, vaccines. Parents make it happen. That's parenting. And the big part of alienation cases is to allow the targeted parent to be put back into the role of being a parent. Targeted parents have been completely ripped off from the kids. They have been undermined. Their role has been discounted. We want to empower them. We want to under-empower the over-empowered children, and we want to start empowering the targeted parent. And that's where good judges make a difference.
And I think my takeaway from this, and we are running out, we ran out of time, we ran over time actually. My key takeaway from this is really we have to be the empowered parents to take charge and take the driver's seat here, and we have to enforce this and in a professional way, not just by complaining and reacting to problems. So yeah, thank you so much. This has been so insightful, and I apologize, everyone. There's like a million questions in the chat. There's no way we can pick up all of this, but he has been so generous. Ashish has generously offered for us for 5 people to get free 1-hour consultation with him on the phone as a part of helping us at Victim to Hero fundraising campaign. So we're going to announce how you can get a chance to get a free consultation with him in the next, I don't know, soon. We're going to try to figure out how to announce that. Also, look out next week. We have an interview with Karen Woodall. She's a psychotherapist, and she's going to talk about what's going on in the children's minds as the child is going through this, and what you can do as alienated parents to repair and reverse the damage of parental alienation. And then we're also going to have interview with Linda Gottlieb and Jennifer Harmon coming up. So we will announce that. So just look out on our Facebook page. And thank you so much, everyone, for being a part of this. Please help spread the word. And thank you so much, Ashish, for being here today. I'm so grateful. Thank you.
Please note that the discussions here are not intended to substitute for legal advice. Please seek the advice and help from a lawyer regarding any legal matters.